Good afternoon, everyone. Thank you for getting on NERCA's webinar today on Massachusetts Paid Family Medical and Medical Leave Update. We have some good information for you today in a PowerPoint. A few housekeeping items. During the presentation, I'll do my best to try to look at the questions coming in and answer them as I go along. There is a questions box or a chat section where you can type in your question. We have all the attendees on mute just so we can reduce the background noise. But if you prefer to ask it in person, you can put your hand up and I'll take you off mute. With that, my name is John Ferrante. I'm the Director of Government and Industry Affairs for NERCA. There's some contact information here in case you want to ask me any questions offline. I apologize for the picture. It's a little frightening looking at it now in real life, but that's me. So if you see me around, say hi. Today, here's kind of an agenda of what we're going to cover. We'll go over a background of the law, how it came about, an overview of the law's requirements, how it's funded or who's going to pay for it, kind of an example just to walk you through how it's supposed to work, both family and medical leave. Some complicating factors and key problems, what NERCA has been doing, on behalf of our members, and then finally a critical employer timeline, which will kind of lay out what you need to do between now and the time the contributions begin in October now of this year. So just some background. Almost a year ago, the Grand Bargain was signed into law by Governor Baker. It provided a 15-hour minimum wage, sales tax holiday, and paid family and medical leave. The implementation timeline here, again, this wasn't the one that they originally released. Obviously, for anyone paying attention, there's been a 3-month delay now on the payroll deductions for paid family leave. So we've changed this timeline around. But this represents to date what the program is going to look like. So the original draft regulations came out at the beginning of this year. They went through public comment and the final draft regulations have just been released. The original employee notification deadline, which as I'm looking at it now, I didn't change, but that was originally June 30th, 2019, and now it's going to be moved up to September 30th, 2019, right before the payroll deductions begin on October 1st. And then the payroll deductions are going to be submitted quarterly. So by January 31st of 2020, that's when the first round of the payroll contributions are due. 2021, the paid family medical or the paid medical leave begins. So employees will be able to take that. And then July of 2021, that's when paid family leave begins. So what does the law require? So employers with 25 or more employees, they have to contribute through the payroll tax. So basically it's not quite, but almost a 50-50 split between employers and employees. And what that pays for is the wage replacement of an employee. So if somebody goes out on leave, the State Department of Family Medical Leave will be sending a check to individuals who qualify. It'll be a slightly reduced benefit, but it'll be similar to unemployment. In addition, health coverage at whatever type is provided by an employer must be maintained while an employee is on leave. So that is another factor that employers really have to pay attention to, is however your health insurance is structured, if you offer it or if you don't. But if you offer it, I guess you have to continue to pay whatever percent of it that you currently do. In addition, the actual benefit is employees can take 20 weeks of personal medical leave. Generally, that is going to be inpatient or some kind of ongoing treatment, and 12 weeks of family medical leave, which includes having to care for a sick family member or parental leave like paternity leave. Maternity leave obviously would fall under the 20 weeks personal medical leave because that's a medical condition. And then finally, there's 26 weeks total, and that can be a combination of personal or medical or family leave, or there is also a service member category where if you are a service member who's been injured in active duty or is getting activated, you can take 26 weeks of leave for that. The wage replacement formula is the same formula that's used for the Massachusetts unemployment system. It's $850 per week maximum based on that formula below, which is 80% of wages up to the half of the average weekly wage, which is currently $670. Then 50% of wages up to the 850 max. So kind of depending on what your employees are being paid, they'll either be able to they'll be getting a fairly decent portion of their paycheck if they go out on leave. Eligibility for leave. So again, it's the same eligibility requirements as unemployment. An employee has to have 15 weeks of earnings and have made at least $4,700 in the last 12 months. There is a 7-day waiting period for leave, during which they can use some of their earned sick time if they have that built up. In terms of eligibility documentation rules, so for medical leave, you are required to have a doctor's note, so some kind of documentation from your doctor, and same for family leave. For parental leave, like paternity leave, you'll need a birth certificate and things like that. And then service member leave, again, that's the special category. They have to submit their orders of activation or return from duty with a serious medical condition. And again, this slide just kind of lays out in more detail the various types of certification and documentation required for the different types of leave. And we will have this webinar recorded, and I will send out our the slides here so everybody has a copy of those as well. Employer requirements. So employers have to register through the Mass Tax Connect, which is the Department of Revenue's online portal. I would assume a lot of companies are already using this system, but if you're not, then you have to sign up for it under this new program. So make sure you get on that. You'll have to submit quarterly information regarding employees and compensation. So, names, wages, all that kind of stuff. And then contributions must be made within 30 days at the end of the quarter. So that's, again, the quarterly contribution from the payroll deduction that I was speaking about earlier. In addition, another employer requirement, which you should be prepared to respond to, is that the Department of Family Medical Leave, if they get an application for leave, they're going to ask you for certain information. And because there's a certain time period in which an application has to be processed, an employer only has 5 days to provide this information. So you have to include the wages, a description of the position, weekly hours worked, any prior requests, a description of your own leave policy if you have one, and then any other information. And this is where they say that an employer, if you think it's a fraudulent claim, this is where you can submit that information and say, so-and-so is full of it, so to speak. We do have a question. Will current payroll service providers take care of the sign-up and payroll deductions? I'm not sure about this, what the sign-up means, but most payroll service providers, Paychex or one of those, they are prepared to do this deduction. They're doing it for most of their clients, obviously. So if you use a payroll service, I would just speak with them about it, and they should know exactly what needs to be done and be able to get that payroll deduction all set up for you, depending on the size, if you're an employer of 25 or more or what. So now we're getting into the funding. Again, we're all familiar. I've been speaking about it. the payroll tax. So given the 3-month delay that just went into place for this law in order to let everybody get their ducks in a row, the original payroll tax was going to be 0.63% on gross wages, and now it's going to be 0.75%, and that increase is only to make up the difference or the loss of those 3 months for the delay. Most people seem to think that the first opportunity to decrease the amount of that money, the state will go ahead and do that because it's far above what other states are deducting to pay for programs like this. So we expect that to come down within the first couple of years there. So if you look at this chart, this is how the contribution ends up breaking down. The 0.75% payroll deduction is split between medical leave and family leave. And medical leave is obviously a much larger percent of that 0.75. And the employer share of ends up being 60% of the medical leave and 0% of the family leave. So that's if you're an employer of 25 or more. If you're an employer of 25 or less, all you have to do is deduct the employee's share, which is the 40% of medical leave and 100% of family leave. But basically, when you look at the numbers underneath that chart, you'll see the employer ends up paying 0.37125%, and the employee pays 0.37875%. So it comes out pretty close in terms of the split, but it's not quite 50-50. So definitely something to pay attention to. But again, your payroll service should have that all worked out, given that they're doing it for everybody. Employee and workforce count. So when we talk about the 25 employees, there is a very specific way that the state wants you to calculate. Basically, any W-2 employees, including full, part-time, and seasonal, are counted as an employee. And there is a certain criteria. If you have 1099 MISC employees, if they make up more than 50% of your workforce, then you have to count all of them in your count. And if they're below 50%, then you don't have to count any of them. So for each pay period, you add up the number of W-2 employees and the 1099s if that applies to you. And then you just divide by the number of pay periods. So you add up the total number of W-2s and then divide by your number of pay periods, and that'll let you know if you meet that 25 employee number or not. And then for self-employed individuals, you are able to opt in. So if you're a smaller company and maybe you work for yourself or have a small crew, you can opt in, but that would be up to you. Employer geographic requirements. So this one's been probably given me the most headaches. And basically this is when is an employer covered and when is an employee covered under this law. And basically they took the language from the unemployment statute and said that was the way that they were going to do it. But again, it's very unclear exactly about how it works. I'll just read you the regulation and you can try to make sense of it on your own. Under these regulations, an employer or covered business entity shall be considered a Massachusetts employer or covered business entity with respect to services performed by a covered individual for the employer or covered business entity. And a covered individual shall be considered a Massachusetts covered individual with respect to all services provided within or both within and without the Commonwealth for an employer or covered business entity. So basically that just says, an employee can be considered a Massachusetts covered individual even if they work outside of the state, if the service is localized in the Commonwealth. So you could work both in New Hampshire and Massachusetts and still be considered a covered individual, or the service is not localized in any state, but some part of the service is performed in the Commonwealth. So again, it's totally unclear language, but my rule of thumb here is if you do work in Massachusetts, your employees who do work here are probably covered, and that's how I would approach it. But again, that whole thing is one of the biggest headaches, and I think it'll take someone with a legal degree to give you a straight answer on it. As for benefits during leave, so employment benefits are defined as all benefits provided or made available to employees by an employer, including but not limited to health insurance. So health insurance is kind of the big key here. During the duration of an employee's family and medical leave, the employer shall continue to provide for and contribute to the employee's employment-related health insurance benefits. So that basically says it all. If you provide health insurance for your employees, whatever premiums you're paying for them, you must continue to pay that. And then if they share the cost, then they'll have to continue to pay their portion as well. So how is this supposed to work? So we have Joe. He's a roofer for Skylight Inc. I have his compensation laid out there. They do provide him some health insurance, and he met the eligibility, and is going to be paid $731.27 by the state because he makes $25 an hour. So basically, this just shows the payroll contributions that both Joe and Skylight Inc. are going to make to the Department of Family and Medical Leave, and that cost obviously over time and depending on the usage of the program will end up paying for Joe to go out on leave. So Joe develops a serious medical condition and goes out on personal medical leave for 16 weeks. So he gets a doctor's note, submits the claim to the department. The department confirms the information and then approves the application after no more than 14 days. So that's the timeline that I was telling you about. That's why the employer must submit the information to the department within those 5 days, and then the department pays the wage replacement to Joe after no more than another 14 days. So basically, the whole process is supposed to take less than a month. I would imagine that they're hoping to do it much faster than that. But basically, after Joe's application is approved, the Department of Family Medical Leave will pay him that wage replacement based on the formula. And then both Joe and Skylight Inc. will continue to pay their benefit share to the health insurer. So after spending so much time at home, Joe's wife's now pregnant, and he has a baby a few months after he returns to work. Being a good father, Joe will take the remaining 10 weeks of his maximum allowable leave. So he used 16 weeks at the beginning of the year. He's going to use 10 weeks at the end of the year. So same deal, Joe notifies the company. He becomes a father, submits all the information to the department, including the birth certificate, and the department confirms the information, ends up paying the same benefits. It's a very similar process. And so here's kind of how it ended up being. You know, Joe's 2022, he worked half the year and he was out on leave half the year. And that's what the program's kind of set up to do, is let him, you know, take care of himself when he's sick and then take care of his kids when they're born. And then he also was kept in coverage because both him and his employer continued paying their health insurance benefits. So complicating factors. These are kind of some of the ins and outs of the program, which I'm sure will give people headaches and drive some people up the wall. But intermittent leave. So the employee may take intermittent leave for the following reasons. So if you go on family leave to bond with a child, that's the only one of these options that would require you to give them permission. Otherwise, if they want to take family leave, if it's medically necessary, then they're allowed to. Then they're allowed to, and they can do it on an intermittent basis, which basically means if they're working 40 hours a week, they can say, I can only work 20 hours a week, and I need, to be accommodated, and the state will give them some money for those 20 hours that they're on leave, and you'll continue to pay them their full rate while they continue working for you. There are some protections built into that for employers. For instance, if an employee fails to adhere to an established intermittent leave schedule, then you can subject them to discipline. So basically, if they don't stick to the deal, then there are some options for you. But generally, I think that one will be a real challenge. In addition, there are reduction of benefits, and that's related to employees that are collecting more than one type of wage replacement, so to speak. So if an employee takes workers' comp or short-term disability, or if the employer provides a permanent disability benefit, then those will all diminish the amount of wage replacement money that the state will pay to the employee if they go out on leave. However, if you have a short-term disability policy, which some of you might, if you have a short-term disability, that doesn't decrease the benefits. That's actually added on top, unless the total amount of that benefit will be more than their average weekly wage, which is pretty unlikely. But that's something we're encouraging all of our Massachusetts employers to look at, is if you have a short-term disability policy, take another look at it and see if that benefit is really going to be necessary with this new system moving forward, or if that's something that you might want to consider phasing out as this program comes online. In addition, employees can apply for extensions of benefits. So, this is set up in case an employee, goes in for treatment and, doesn't get well as fast as the doctor might have thought or whatever. They can file to stay out longer. So if they had originally applied for 8 weeks and then they say, oh, I'm going to need 12, then they can submit an application for an extension. It does require additional documentation, so you will have to get that doctor's note again saying, treatment's taking longer than expected and all of that. But yeah, that's another facet of the program to be aware of. In addition, job protection during layoff. So it has the same requirements as the Massachusetts Earned Sick Time law. So in most cases, employers will be required to reinstate the employee that takes leave. There is an exception for layoff, which obviously has an important place in our industry. So an employer shall not be required to restore an employee if other employees of equal length of service, credit, and status in the same or equivalent positions have been laid off due to economic conditions or other changes in operating conditions. So if you've, laid off a whole crew of roofers and this person thinks they're going to slide back into a spot when they return, you're not required to do that, but I would just inform them and be cognizant of legal exposure if you are not letting people come back to work and you haven't done something like a layoff. Again, the transient nature of our industry, it's an issue that an employee could gain eligibility for this program under one company and then take leave when employed by another. So as it's currently written, the current employer is the one who'd be on the hook for those health insurance costs. Obviously, the wage replacement would already have been paid by the original employer, but just something to keep in mind as well. And then finally, one thing that was new in the final draft of the regulations was they wrote in a section which allows employers to apply a uniform fitness for duty test to anyone returning from medical leave. And this is something I would definitely recommend all of our roofing contractors and even even manufacturers or suppliers take into consideration, because what you can do is you have to determine the essential functions of each position, and come up with an idea of how those essential functions might have been impacted by the health condition. So if you have a list of essential functions, and say somebody goes out and gets knee surgery, you say, well, I'm going to need a doctor to sign off that you can perform all of these functions, given you just had your knee reconstructed or whatever. And if they're unable to do that, then that will also waive the job protection requirement. So I would come up with a list of those essential functions, job description, that kind of thing, and have those ready for any employee who's going out on medical leave to say, well, I'm going to need you to get these signed off on in order for you to come back to work. But again, that's determined specifically by the position and the health condition. So you're going to have to specify which health conditions need which function, or might affect which functions, and all of that. So just take that under consideration, because I think that'll be an important protection for employers when people are coming back from leave. So key problems, aside from some of the ones I already laid out, but the one that's kind of held up the process here was the unknown tax implications of the payroll deductions. So they're still waiting for a determination from the IRS on how to treat that payroll deduction. And again, the geographic requirements, it's still not entirely clear about which employees and employers are covered by this law. So I'm hoping that there'll be additional guidance coming out from the department or from the state that we can look to before the rollout. Well, obviously the rollout's not until 2021, but it would be nice to have all of this figured out before then. What's NERCA been up to? So we've had meetings with the Executive Office of Workforce and Labor Development and the Department of Family Medical Leave regarding their regulations. It's a lot of the writing has been on the wall in terms of how the program is going to be structured, but we've just tried to be as informed as we can all the way through and let them know our concerns. I think I think there are certain things that have been added back in which will be good for employers, including the fitness for duty and things like that. So hopefully it won't be as much of a nightmare as we're imagining. And then informing members, again, we've been sending out, the monthly newsletters have a lot of information about paid family leave, and we've definitely had a lot of questions coming into the office directly. So hopefully we've been helpful in answering those. So getting onto the critical employer timeline. Again, so there is an employee notification requirement. I guess I didn't touch on it earlier, but basically by September 30th, 2019, all employers are required to display a poster in their workplace and provide written notice of the paid family medical leave program to their employees. The notice was actually a document created by the state, would be the easiest way to do it. You just take that document, fill in your company information, fill in the percentages from the contribution chart that I showed you, and then you get the employee to sign that document, and you save that signature as an acknowledgement that you completed this requirement. So the state is trying to protect both employees and employers by saying, we want the employees to be notified, but we want the employers to have proof of this notification. So those are things that you should definitely be doing over this summer so that you can have all those checked off. And you will want to include it in any of your onboarding materials or whatever. If you have an employee handbook, when somebody gets it, have them sign that acknowledgement form as well. And then October 1st, 2019, the payroll deductions begin. Before that, you'll want to know whether or not you're an employer of 25 or more, and you'll want to register your business through Mass Tax Connect. And then as the question kind of pointed out, if you have a payroll company, reach out to them and just make sure that they know you're a Massachusetts employer and you're going to participate and all that kind of stuff. And then January 31st, 2021, that's when the first set of deductions will be remitted to Mass Tax Connect. And then there's some additional resources here. Again, I'll send out this presentation with all of the information in it, and all these links will work for you. So everyone will have a copy of that. The presentation's recorded, so if you need to go back to it and review, we'll have a recording available as well. And then my contact information's all right here. And we got plenty of time for other questions or comments or anything. I'd be happy to answer anything anybody wants to know as best as I can. I'll just give it a second here to see if anything else comes in. Again, you can type your questions into the question box down there or the chat box, or feel free to email me at the email address right there, and I can definitely answer those as well.
John, there is one question down in the box, if you can grab it, please. I don't know if you can see it.
Oh yeah, no, yep, I answered that one. I didn't know how to mark it as answered.
Okay.
Well, I don't see any more questions coming in. We'll let everyone get back to their lunch or whatever, but yep, definitely feel free to contact me, and I'll send out the presentation and recording link to everybody. Thank you.